everyone. My name is Jennifer Olmstead. I am the Senior Director of Governance and Operations here at the San Diego County Medical Society. In partnership with the Doctors Company, I'd like to welcome you to tonight's webinar on the impact of a medical board investigation on your practice. We've got two terrific presenters for you this evening. Kathleen Stillwell is the Senior Patient Safety Risk Manager at the Doctors Company, and Jehan Jayakumar from the Law Office of Carlson and Jayakumar. Now, before I hand things over to Kathleen, I want to quickly remind everyone that tonight's webinar has been approved for 1 hour of CME credit. Instructions on how to claim the CME credit were emailed out to everyone earlier this week, but we'll send that out again to everyone again tomorrow. Lastly, we have reserved time at the end of the program for Q&A. So if you have any questions as we're moving through the presentation, please feel free to type them in the chat box, and we'll get to them once our speakers have finished. And now I'd like to introduce Kathleen Stillwell. Kathleen?
Thank you so much, Jen. Our program tonight, you will need the activity code 4096. That's on the instructions that have been sent out to you. And so this program tonight is really an important insight into what is going on with the medical board. There are new things going on, and what is the medical board doing? What are they looking at? We're accredited for AMA. We're also accredited for dentists by ADA. I am the Senior Patient Safety Risk Manager, and I now handle all the accounts in San Diego as well. So be sure at the end that you write down my cell phone number, because it's much easier to get me on the cell phone than on the 800 number, and I can assist you. But I do want to take a moment and give a little deeper introduction to Jehan Jayakumar, a founding partner of Carlson and Jayakumar. And they are endorsed business partners with San Diego County Medical Society, with Orange County Medical Association, and with Los Angeles County Medical Society, with offices in LA and in South County. And I'm really pleased to have him with me. He's presented this with me before, and he has a lot of great insights into this program and what is going on. The firm specializes in medical board issues, as well as labor, employment, and healthcare law. They are the firm that the Doctors Company has vetted and refers doctors to when they call and say, I need a contract, I'm selling a practice, I'm bringing someone on board, who can I go to? And they are our go-to group. I'm going to start with a thought of inspiration from Theodore Roosevelt, our 26th President of the United States. No man is above the law, and no man is below it. Nor do we ask any man's permission when we ask him to obey it. I'm not going to go through every slide, everything, but I want to point out something on the objectives, is that to look at your opportunity to identify opportunities to reduce the risk of being reported to the state licensing board. And this is going to be whether it's an MD, DO, PA board, or the nursing board. And if you are an advanced practice provider, you will be able to get 1 hour of continuing education credit for attending this tonight when you do the online CME evaluation. So the medical board investigation will change your life. If you've ever been through one, you already know that. The things that are most commonly reported and complained about relate to this slide: unprofessional conduct, breach of confidence, record alteration, fraudulent insurance, misleading advertising, arrest, conviction, or DUI. And what that is on arrest, conviction, or DUI is usually that the doctor didn't report it to the board. And you're going to hear tonight more about that from Jehan. Office practice issues really are the highest volume, more than unprofessional conduct. And that, believe it or not, the #1 problem is failure to provide medical records in accordance with the requirements. And we're going to go through that tonight. Wrongful patient termination is just when patients are dismissed, they think they're abandoned, and they report, they retaliate. And there's a big increase in the last 18 months of patients retaliating by complaining to the medical board. And then failure to sign a death certificate. Well, a coroner's office or a mortuary has to have a signature on the death certificate, and they look for the last physician that saw the patient. And somebody says, well, that physician's not here anymore, they left our practice. Then the medical director or another physician in that office needs to sign it. And I just want to remind you all that there's no liability for signing a death certificate. A patient dies for one of two reasons. They stop breathing or their heart stopped. And then it's related to. And related to is, what do you have in the record that you treated him for, or do you know? Or also the coroner and the mortuary already has something about what was going on if this was a hospitalized patient. Patient abandonment is, I put that as a separate item because that's something that they can mark and say, they abandoned me, they wouldn't see me. And we have a big increase in that as well. You know, this has been around for over 12 years, that the doctors have to have in their office where it can be seen by everyone. And it's recommended that it's in the lobby. You don't have to put it in every exam room, but you put it in your lobby. So when people come in, they see it. So they can see right where to go to call and complain about you. Here's just a couple of California headline news. I'm not going to go over all of them, but I want to point out a couple. The second one, doctor arrested for domestic violence during a fight with the ex-wife's boyfriend. And this is something that actually came up with, we had a doctor, and they were reported, of course, to the board gets that, because that's going to fall under, you know, when you're arrested, depends on what the outcome is. Was it reported? And you'll hear more about that tonight. There have been a number of issues where physicians have been put on probation for negligent treatment and failure to maintain appropriate medical records documentation. And where I'm finding this becoming a hot issue is, you know, starting last year, the medical board is contracted with the UC system to audit the cures database. So I lose count of how many letters I get from doctors that say, I got this letter from the medical board, and it says your cures account has been audited, and the following patients were prescribed scheduled 2 through 5 drugs without appropriate documentation in the cures database. Please respond and provide support documentation within 30 days of the date of this letter. So I want to say something. If you get a letter, be sure you keep the envelope, because the letter might be dated June 5th, but the postmark might be June 18th. And so 30 days within the date of this letter, you will be able to say, no, the letter just came. And I've had doctors in the last month call me, and they got the letter, and it's due in 3 days. Now, if you're with the doctor's company, we help you with this under Medigard. We assign especially a medical board attorney, and they create all the responses. But I just want to say, if you get a letter from the medical board, be sure that you have educated your staff that should be immediately brought to your attention, and that they must keep the envelope so we have the date of the postmark. This is physicians getting probation for unapproved drug use. And this I wanted to point out because it's increasingly coming up. Many physicians are buying drugs from outside of the United States because they can get them cheaper, they can get them faster, and they have a workaround from Canada, from other countries. And I just want you to know that we're now seeing physicians get licensed in California, getting probation and sanctions by the medical board. And this is actually a San Diego-based physician who got 3 years of probation for using unapproved misbranded cosmetic drugs. And these things they get in the news. The other thing I want to talk about just for a moment is that Senate Bill 1448, known as the Patient's Right to Know Act of 2018, which passed some time ago, requires doctors to provide patients with disclosure if they're on probation, the status and the length of the probation, the end of the date, and any restrictions. And so if you don't, and the patient can then bring an action against you with the medical board, then you have another action. So I just want you to know, any physician that is on probation has to disclose it to the patient. And if anyone ever that comes up for you, you give me a call if you're with the doctor's company. If not, call your own carrier and say, what is the best way to disclose this? Medical board investigations include many types of professional misconduct complaints. This is the list. I'm not going to go through all of it because you're going to hear more about these in detail, but I did want to talk for a moment about misdiagnosis, treatment, medication prescribing, and surgical complications. Those are things that lend themselves more to going into the direction of a malpractice lawsuit, possibly. What I want to tell you is that in our claims analysis of our claims, and we've been in business now 50 years this year, that we see 85 to 87% of the malpractice claims against TDC physicians are related to diagnostic error. And diagnostic error includes wrong diagnosis, delayed diagnosis, failure to diagnose, failure to refer to a specialist, and failure to follow up after you make a referral. So I just want to say, I like to just make a pitch for that. Be sure that you are staying up when you refer somebody. Have your office call. Did they call that office? Did they show up? They didn't. If not, 2 calls and then a letter. Medical board triggers that get the board's attention are pretty straightforward. Complaints that come directly to them, settlements over state reporting limits over 2999, arrests or convictions, 805 reports, and of course, unfavorable media attention. And that has increased dramatically, unfavorable media attention. It's in the news, the physicians in the news, the practices in the news, and also what is posted on social media has also gotten the attention of the medical board. Medical board also had this law that took effect January 1, 2024. It's a year and a half ago, but I wanted to bring it up because no physicians, when I talked to them, seemed to be aware of it. This was a state Senate bill 815 that made a change in the Business and Professions Code, which governs your license. Any licensee who fails or refuses to comply with a request for the certified medical records of a patient that is accompanied by the patient's written authorization for release of records to the board within 15 days of receiving the request and authorization, you get a civil penalty of $1,000 a day for each day that the documents have not been produced after the 15th day. And that can go up to $10,000 unless the licensee can prove and provide documents within this time period for good cause. An example would be, I have to get the records out of storage, or the person who pulls the records out is off or on vacation. I need a little bit more time. And again, this is going to already come, if it's a medical board request, you already would have reported it to us from your letter from the medical board, or to your carrier that you got a letter from the medical board. And so we will have an attorney who will be up on this. But a lot of physicians don't realize that there's a fine $1,000 a day. Also, while this says you have that accompanied by a patient's written authorization for release of records to the board, in fact, most of the letters that come from the board saying to send us the records often don't have a written authorization. Don't worry about it. They're a regulatory agency, and under law, they don't even have to have it. But they're trying to do a better job of getting it after Senate Bill 815 passed. I think the big thing that I want to talk about before I turn it over to Jay Han are the new medical board enforcement changes. And these took effect in January this year. They were approved last year by the legislature, and that included funding for them. The Compliant Liaison Unit establishes a new staff unit with the following duties. They will respond to communications from the public about complaint review and enforcement process. After a complaint is referred for field investigation, the Complaint Liaison Unit staff will assist with coordinating communications between the complainant and the investigators. Let me just say that everything on this slide, and the next slide I'm going to show you, never existed before this year. There wasn't a place for the complainant or their representative to go. So this is a whole new game. Following any disciplinary decision, respond to questions from the complainant regarding an appeals process available to the disciplined licensee. That's a whole new thing. On this slide, it continues. Their role and the Compliance Enforcement Unit is to provide the complainant with an understanding of the board's enforcement process, including laws and policies, and to evaluate and respond to requests from complainants to review a complaint closure that the complainant believes was made in error. This is a whole new ballgame too. We never had that. It's done, it's adjudicated, it's over. You were found innocent of everything, and that's what the majority of our doctors are. Very few of them have any kind of action or sanctions. It's in a minority, and you're going to see that when Jehan takes you through some data. But this is, they closed it and they didn't punish you. Now the complainant or their representative can come back and say, wait, this isn't fair. We want an appeal. This shouldn't have happened. They've also added something called patient impact statements. After a complainant is referred for a field investigation, and if it's closed without a field investigation, you get a letter that can take a year or more. But then if there's going to be an investigation, complainant, patient, or a patient representative. Do you hear that? The complainant, the patient, or their representative has the opportunity to provide a statement to the board regarding harm they experienced. And that impact statement will be considered by the board's disciplinary panel when adjudicating the relevant case. Lastly, look at what else they've added. This compliance liaison unit is going to do interviews for quality of care complaints. They're not interviewing the doctor. They're interviewing the complainant, the patient, or the patient representative. If request for an interview is not responded to within 30 days, the board may close the complaint if otherwise warranted. Now, I have been asked in other sessions, if we didn't realize, if a patient says they didn't realize and they didn't do it within the 30 days, are they going to be able to still make a quality of care complaint or have this interview? And my response to that is to take you back to the complainant can ask for an appeal or to reopen something that was closed. So the answer is probably, maybe, I don't know. I also want to tell you that I have been attempting to figure out who and what kind of people are they hiring for this liaison unit. Right now, I'm still in the weeds trying to find that out. They won't tell who is in that liaison department. I think they haven't fully staffed it yet. And we haven't seen any, what I'm going to call repercussions of this unit yet, but it will be coming. So I think it's really important for you all to be aware that this is all new, the liaison compliance unit. This is my last slide before I turn it over to Jehan. And this is the kind of letter that you may get. I am an analyst with the Medical Board of California. Complaint was submitted regarding your overall prescribing or whatever. I don't have the whole letter. I have attached a letter, a formal requesting information to this complaint. Do not hesitate to call me. And I would just want to leave you with this thought. It's a commandment. Thou shalt never respond to the medical board yourself on a letter, on a phone call, if you're approached in public, because we have this happen to doctors. They get their cell phone, say, this is investigator Joe Blow, and I'm investigating a complaint against you from Mary Smith, and I need to ask you some questions. What we tell our attorneys, there's only one response. I'm sorry, on the advice of counsel, I cannot speak with you. Please send any questions you have to me at my name, at my office, and we will follow up with you. Do not talk with them. I've had physicians met in their church parking lot, in the market, in the produce section, at the gas station, at a 7-Eleven store. They just are out there. The investigators are not doctors. A lot of their investigators are retired police officers, and their style is just sort of in your face. And even on the phone, and doctors say, well, why are they calling my cell phone? How do they get it? And if they call you, just delete the call. Don't even respond and say, I'm not going to talk to you. Just delete it. And let your office know if someone calls and says, I want to schedule an appointment to talk with the doctor about this complaint. Say, I'm sorry, the doctor has been advised by legal counsel not to speak with anyone. If you have any questions, please direct them to the office, and I'll be happy to give you the address. With that, I'm going to turn it over to Jehan.
Thank you, Kathleen. As Kathleen mentioned, my name is Jehan Jayakumar. I'm a partner at Crossan and Jayakumar. My partner and I have been practicing in the healthcare space at our current firm, rather, for the last 18 years, and then together for about 20 years. Him a few years longer than me, but suffice to say, it's been quite a while. I'm happy to be here today, and as Kathleen mentioned, we represent providers and hospitals and facilities all over California with matters like involving the boards, as well as matters involving insurance companies, employees, etc. So, as Kathleen mentioned, the first thing you're going to get is probably a letter, well, hopefully not, but a letter from the board alleging that maybe perhaps a patient is accusing you of some kind of misconduct. It could be something having to do with the level of care or the adequacy of care. It could deal with sexual misconduct, like this one we have here in front of us. It could deal with billing or some other matter that maybe is even outside of your practice. As Kathleen mentioned, the most important thing to do, contact your carrier, have them appoint counsel. If for some reason your insurance policy doesn't provide for counsel, go ahead and get counsel on your own and have counsel respond on your behalf. If you are running up against a deadline, feel free to just drop them a note and say, I'm retaining counsel and I'll allow my counsel to contact you, as soon as possible. But as Kathleen mentioned, never ever communicate with them directly yourself on the phone or in person. If you have to drop them a note in writing, either by letter or email, that's okay as long as it's short and it just says, I'll have my counsel contact you ASAP. So when you do have a board investigation and that investigation ends up in what's called an accusation is the formal legal document that initiates a legal action to either suspend or revoke or put your license on probation. That accusation is sort of the launching document, the equivalent of what we call a complaint in civil court. So once that's filed, there's now a formal action against you. You don't have to, but you should retain counsel and have your counsel defend you in that action. That action is much like a trial in that there are witnesses, there's evidence that's submitted to the judge, and the judge makes a factual finding as to what did or did not occur. Based on that finding, the judge would make a recommendation back to the board, who would then accept or reject the judge's recommendation. In the event that you are found to have violated the law, and the judge recommends probation, suspension, or revocation of your license, you will also be ordered as part of that judgment, you'll be ordered to pay the cost of investigation and enforcement. So those include, of course, the cost of the investigator coming out to your office, getting records, interviewing witnesses, and also the cost of the attorney general who will represent the board in the case in bringing the action against your license. So you are basically paying the government to take action against your license if you are found to have violated the law. So it's really important that you take what steps you can to minimize the chance of that happening. And then if you do face an action, that you do retain proper counsel that has experience in this area that can minimize the chances of you having to pay one of these cost awards. And I'll also add one more note, which is, for example, if you're on probation, that probation will not be lifted until and unless you pay that cost award. So even if your probation is 3 years and you've done your 3 years, you've done your classes, you've done all you're supposed to do, if you haven't paid those costs of investigation, your probation will remain in effect. As Kathleen mentioned earlier, there have been some changes in the law of late, and there are new categories of unprofessional conduct. Unprofessional conduct is kind of the catch-all cause of action we see in licensing cases, whether you're accused of overprescribing or touching a patient or billing inappropriately, they'll always add in the claim of unprofessional conduct because typically anything that they believe to be improper is also going to be unprofessional. Okay, and so we have these new categories of unprofessional conduct. First of all, a failure to maintain adequate records relating to services provided to the patient going back at least 7 years after the last date of service. In this day and age of EMR and scanning and whatnot, there's really no reason not to have patient records going back at least 7 years. Another new cause of action is basically the failure of the licensee, of the doctor in this case, without good cause, to attend and participate in the interview with the board investigators within 30 calendar days of the request. I oftentimes get pushback from doctors as to, and I mean all licensees really, as to whether or not they should appear for the interview. And that kind of blows my mind because, of course, they're going to be appearing with the interview with myself or one of my colleagues. So they're going to have counsel at that interview. But that interview is your chance as a licensee, as a doctor, to get out your side of the story. So in cases involving, for example, inappropriate conduct, you want to have the chance to provide your side of the story. You want to be able to provide some color and context, because at that point or prior to that interview, all the board really has is one side of the story, and that's the patient side, and that isn't always complete or accurate. And so I think, at least my personal opinion, it's vitally important that the licensee appear for the interview and have counsel at that interview. And in my experience, when you do that, typically most cases are then dismissed without any further action. Okay, most of our cases that we handle at that stage are dismissed without further action. It's fairly rare for us to see a case through investigation and have that lead end up in an accusation. It's not impossible, but it's usually unlikely. Okay. Another new cause of action is any action by a doctor that's intended to sort of bully or coerce the patient or the representative into withdrawing their consent to release patient records. So if you know that the patient is complaining to the medical board and you call the patient and say, hey, you better rescind that consent or I'm going to sue you, I'm going to come after you, I'm going to beat you up, that's going to lead to an action against your license. So obviously don't do that. Along the same lines, you're also prohibited from dissuading, intimidating, or tampering with any person to prevent them from reporting or testifying about a licensee. Now, if in the unlikely event that you do see an accusation and a legal action against your license, the most common outcome, I would say, is probation. So what's probation? Probation is a limit on your license that lasts for a finite period of time, typically anywhere between 3 and 7 years, depending on the nature of the action against you and why they're bringing the action against you. During that probationary period, you are required to obey certain laws. You might be required, for example, if the action against you is based on drug or alcohol abuse, you may be required to submit to testing. If the action against you is based on documentation, you may be required to take a record-keeping course. If the action against you is based on domestic violence, you might be required to take some kind of anger monitoring or counseling and go through that. Anger management, rather, not anger monitoring, but anger management. And so another example, if you have a billing issue and billing allegations, they may require that you pay someone to review your bills, randomly review your bills to make sure that you're billing appropriately. And then, of course, the board itself has probation costs in monitoring your probation, making sure that you're following the rules. And you also have to pay those costs associated with the probation each and every year of your probation until the probation expires. There are some ways where you can apply to have that probation ended early. There's a legal process for that. It's slow, it's a bit clumsy, but it can be done. So how do we see complaints? The most common way we see complaints these days is folks jumping on their phone or their iPad or their laptop, going to the medical board's website and submitting a complaint online, as we see here. And what we oftentimes see nowadays is this complaint mechanism being used to either remedy or to sort of rectify or even just seek revenge for a civil wrong. So for example, if a patient wants a refund and they don't get it, or if an attorney on a personal injury case is unhappy with your lien, they may go on the board's website here and submit a complaint, even though their nature, that the complaint is more civil in nature than having to do with your care or your treatment or your billing. Okay, and so when they file this complaint online, the first thing they do is they check the nature of the complaint, and it could be one of these categories, or it could be all those categories. Okay, and so that's kind of the first step for that complaint process. Now here we have some statistics from, I believe, 2023 and 2024 as to the types of complaints we see and who makes them, right? As you can see, the most common type of complaint has to do with gross negligence or incompetence. And so that's going to happen when a patient believes that you've committed malpractice, or a patient believes that you performed a procedure that you're not qualified to perform. You're going to see that gross negligence, incompetence accusation. You're also going to see that when you have other sort of uh, related claims, like, for example, overprescribing or overtreating or billing inappropriately, you might also see a gross negligence claim on top of that billing claim. And then again, unprofessional conduct, kind of a catch-all. We're going to see that whenever you have any kind of almost any kind of claim, you're going to see that claim as well added on top of things. So how do these cases end? We see that out of all these actions, a very common outcome is surrender. That's one we didn't really discuss previously. So the surrender, what happens is, the board brings an action against your license. You either think you're going to lose, or you can't afford to defend yourself, or you're getting ready to retire. You may surrender your license to the board, and when you do, there are still going to be some limitations on you reapplying for reinstatement if you choose to. It's not sort of a get out of jail free card, but it may be an effective way to end the action if you don't plan on practicing, anymore. If your plan is to go to another state, that surrender could impact your ability to get licensed or to keep your license in another state. So we see that when we see revocation, we have probation with suspension, which is pretty rare. Then we have, of course, straight probation, which, as I mentioned earlier, is the most common outcome. We have some other things like public reprimand, which is sort of a slap on the wrist, and things like that. We see of all these cases, only 23 ended up with revocation. So revocation is sort of the death knell. They take away your license permanently. You have to apply to get it back after a number of years, and even then, it's quite a long shot to get it back. So you typically only see revocation in cases involving sexual misconduct or billing fraud. Those are probably the two most common types of claims you see that would lead to revocation. The third would be sort of if you have repeated action against your license, you violate your probation, things like that, then you're probably going to get revoked. The causes for disciplinary action. Sexual misconduct, pretty self-explanatory. We see a lot of that these days, especially in cases, obviously predominantly the cases are female patients making allegations against male doctors. Obviously not the only way that can go, but that's probably the most common. In many situations, you should evaluate whether or not a chaperone will be appropriate when treating patients, especially if the treatment is of an intimate nature. Other causes, conviction of a serious crime that typically involves conviction of a felony. Typically, a misdemeanor by itself is not going to lead to any kind of serious discipline. But if you do have a serious crime, a felony, that's going to lead to discipline. Substance abuse, again, a very common claim that we see. Oftentimes, that'll stem from an arrest for a DUI or a drunk in public or a possession of a controlled substance. You might see that disciplinary action coming down the road if you are arrested for that. Depending on the nature of the arrest and the nature of the allegations, the medical board is oftentimes mainly interested in seeing you rehabilitated and making you, again, safe to treat patients. And so they're willing to work with us if our patients get into rehab, get into treatment, get into counseling, and pursue that earnestly and in good faith. They're often willing to allow the doctor to keep their license when they are found to have broken the law as it pertains to drugs or alcohol. Dishonesty, including filing false or fraudulent claims. Those are much tougher to defend because those oftentimes involve intent, right? It's a premeditated plan to deceive the insurance company or the patient or some other third party. And so in those cases, it's very hard. It's sort of an all or nothing deal, meaning you either prove innocence or you're found to have done it and your license is revoked. Whereas in other cases, like things involving maybe a DUI or drugs or alcohol, you can prove mitigation and maybe sort of split the baby in half and keep your license while being under probation. It's much harder to get probation in a case involving dishonesty or fraud. Same goes for illegal referrals. If you're found to have made illegal referrals, or engaging in a kickback scheme. Again, that typically requires premeditation, or it's alleged that you've done it in a premeditated fashion. And so you're probably looking at revocation there, and it's going to be hard to negotiate with the board to get you less than revocation. Again, all or nothing in those cases, typically. And then finally, knowingly allowing an unlicensed person to practice medicine. We're seeing more of that in the med spa space, where we have where it's alleged that usually an RN is running the practice without any real physician involvement or oversight. And so in that case, the doctor may be accused of allowing the RN to practice medicine without a license. And so that's kind of, I think, the more common modern day situation we see in this particular context. Romantic or sexual relationships with a patient. Obviously, a big no-no. The AMA requires that a physician terminate the patient-physician relationship before initiating a dating, romantic, or sexual relationship with a patient. And so if you are going to start dating a patient, you want to terminate that relationship in writing, the patient relationship in writing, refer them to an appropriate provider who's unrelated to you and unrelated to your practice, and perhaps provide a cooling off period before you begin that relationship between the time you treat the patient and the time the dating begins. Because if and when that relationship goes south, you might be looking at an accusation from the patient that they were coerced or somehow improperly convinced to engage in that relationship with you at the peril of their patient care. A common question we get is, can you lose your license if you get a DUI? And my answer is that always is, depends, right? All DUIs are not the same. The most important thing you can do if you are arrested for a DUI is to get a good criminal lawyer, preferably one who deals with licensees on a regular basis. We have a referral to several criminal lawyers in Southern California who have a specific focus on defending physicians in any kind of criminal case. We don't do it ourselves, but we work sort of hand in glove with them to make sure that the criminal case goes well, so that any ultimate board case that we deal with, also goes well. As a medical doctor, you have to report either a felony charge or any conviction, including a misdemeanor. So if you are charged with a misdemeanor DUI, you're not required to report that charge until or unless you are found or plead guilty of that misdemeanor. Now, in the interim, it's very possible, or I should say likely, that the DA's office reports you to the medical board, and you may get a letter from the board saying, hey, the DA in Orange County or San Diego County told us that you got arrested on July 16th for DUI. What happened? What's going on? Right? You should definitely respond to that letter, but have your attorney respond on your behalf, and hopefully that criminal case is going to get dismissed, or you're going to be exonerated. Now, if you are convicted or you do plead guilty, you're looking at fines and penalties and so on in the criminal case, but also in any kind of board action, right? And so the question then is, hey, if I'm exonerated or the charges are dropped by the DA, that means I'm scot-free with the board, right? Wrong. Even if a jury finds you not guilty, or the DA decides not to press charges, or you plead guilty to a lesser or different offense, for example, you plead guilty to disturbing the peace, for example, right? The medical board, can still bring an action against your license for that alleged DUI. Now, they'd have to go into court and prove that you committed the DUI, but they could still do that. There's no res judicata or collateral estoppel or double jeopardy just because the DA either dropped the charges or because a criminal jury found you not guilty. And why is that? That's because there's different actions and different standards, burdens of proof in different kinds of cases. So if some of you are old enough to remember O.J. Simpson, if you remember, he was found not guilty criminally, but then was found liable civilly for the murder of Nicole Brown Simpson and Ronald Goldman. So that same situation, he was not guilty in one court and guilty in another. In that same way, you could be not guilty in the criminal court, but quote unquote guilty in a licensing action before the medical board. as we mentioned earlier, if you do get a DUI, if you do get a letter from the medical board, the first thing you should do is notify your carrier and figure out if they're going to appoint you counsel. And typically, good carriers like the doctor's company will appoint you qualified and excellent counsel. But if you have another insurance company for whatever reason and they don't and they refuse to or say we don't provide attorneys for this kind of case, go ahead and spend that money and get an attorney to defend you, someone who's experienced in the area, who's handled these cases before, who may have a relationship with the AG's office, the Attorney General's office, that handles the case, because that typically is going to help you immensely. We've been brought in many, many, many times to handle cases when it's almost too late because they've been working with an attorney, either without an attorney or with an attorney who doesn't know what they're doing. And those cases oftentimes don't go well, and we're not always able to get the best result that we possibly could have had we been representing that client from day one. So when you do get a correspondence from the board, whether it's a letter or whether it's a formal accusation, your attorney will prepare a response. If it's going to be on their letterhead, or in the case of an accusation, on their caption, they will draft the response. They will sign it and they will submit it either to the board or to the court. If you are dealing with an investigation and you do have counsel and they represent you, most of the time, the matters are closed at the investigative level. The vast majority of investigations are closed without any kind of action. And one reason is because just because a patient complains doesn't mean you did anything wrong. We've seen patient complaints involving alien abductions and chips in brains and all kinds of nonsense. The board still has to, quote unquote, investigate those allegations, but ultimately they're going to close those cases because there's no cause for discipline. There's no cause for further action. So it's important to remember, it's your license, it's your livelihood at risk. So never talk or meet with the medical board investigator without legal guidance. They may send you a letter, they may show up to your office, they may call you, they may email you. It doesn't matter. It doesn't matter how they approach you, whether it's in writing or in person. Never talk to them without counsel. All you should say, whether it's in writing or verbally, is, please talk to my counsel. I'll have them contact you, or you can contact them. Here's his or her information. Okay. The next important point: it's very common to pick up the phone and call your medical school classmate or your former coworker who's a physician and vent and talk about your problems, talk about this medical board inquiry. Don't do that, because that is discoverable. Okay. Unless the conversation is with your attorney, that conversation is discoverable. So the board can find out what you said. The board can find out what the other doctor told you. All that's discoverable, and it could snowball and make the situation much worse. So any conversations you have about your medical board investigation should be with your attorney, and ideally with no one else. Okay, maybe your spouse, but that's about it. Obviously, if you are going to meet with the board or communicate with the board, have counsel present. Okay, and what we've seen, with this new litigation we've talked about today, these new liaisons, this is sort of a backlash or a result of a couple things. One of them is a few physicians who have refused to provide records to the board over the years and have litigated and gone to the Court of Appeal and the Supreme Court to fight the medical board's right to get access to patient records. Also, we have a lot of cases of alleged widespread abuse by physicians at major hospitals and institutions. So it's kind of a tangential offshoot of the Me Too movement. We've seen more and more of these complaints where we have quite literally dozens of patients alleging that particular physicians at major hospitals and universities, that they allege that they have engaged in improper conduct. And so we've seen an increase in actions, increase in investigations, and an increase in sort of the teeth given to the medical board to enforce these actions. And then, of course, we've also seen some reporting from the LA Times and other publications where they sort of highlighted and spotlighted the boards, and not just medical board, but other boards as well, their delay in bringing action against licensees who have found to have committed serious misconduct. There's been examples of licensees who are in jail for murder or other crimes, but who still have an active medical license or other license because the board has been so slow to take any action against them. And so that's resulted in this sort of overcorrection of having these new laws, having these new departments and investigators and liaisons and so on that are meant to protect the public. So then we got to ask, how do we mitigate our risk and minimize the chances of having one of these investigations? The most common area of complaint is going to be unhappy patients, right? I mentioned this earlier. The nature of the unhappiness maybe has to do with billing. Maybe they feel they were overcharged or incorrectly charged. Maybe they feel that your care wasn't effective in remedying their condition. Maybe, again, this is a common thing we see in a personal injury case. The patient or the attorney feels that you overcharged or that you didn't agree to take enough of a haircut on your lien because the settlement that the patient and the attorney obtained wasn't as good as they hoped it would have been, right? And so even though you're within your rights to tell the patient, hey patient, I charged you appropriately, I gave you all the care that you needed, I did everything by the book. There's no reason to either reduce my bill or reduce my lien or give you a refund. And you can stand on those grounds and stand on principle. But if you do that, you're probably looking at a medical board complaint some weeks or months down the road. And then you're going to have to call your carrier and talk to your lawyer, show up for an interview, and do all those things. So if you have a patient complaint, do what you can, as painful as it may be financially or emotionally, do what you can to make them happy, even if you are in the right. Okay. Um, Sometimes standing on principle is not always the best approach. Sometimes sort of eating some humble pie, even though you're in the right, giving that refund, giving that reduction might 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 avoid problems with the board down the road. And look, if you do get that board complaint, you're probably going to be exonerated. It's probably not going to go anywhere, but it's still going to cause you some stress. It's going to cause you some time. It might cost you some money, and it's going to cost you a lot of heartache. And so if we can nip that in the bud by offering a small refund, by offering a small haircut on that lien, it's going to go a long way. We also want to make sure that the medical record reflects what happened in the office, right? That we had a case recently where the patient came to get a record and got a copy of their records, and it didn't match what happened in the treatment room, and that led to a board investigation. And that's not going so well for that particular doctor. Uh, Also, when appropriate, have a chaperone in the room when you have a particularly sensitive patient examination, or you think the patient themselves might be sensitive. Uh, Err on the side of caution, and have a chaperone in the room. And then finally, if there is harassment in your office, whether it's by a patient or by an employee or by a provider, have a zero tolerance policy and take appropriate action when necessary. And finally, you want to understand by this Zoom today the repercussions and consequences of licensing action, how it works, what the pitfalls are. So after you get that letter from the medical board, the first thing you should do is contact your patient safety risk manager for guidance. In this particular case, TDC, Kathleen, or one of her colleagues will typically appoint an attorney who focuses on medical board actions to assist you with your response, with talking to the board, with providing records to the board. That'll all be done through your attorney. Never speak with the medical board investigator on the phone or in person without your counsel present. Okay, as Kathleen mentioned, she's had many of her insureds who have been approached in public places, churches, stores. It seems friendly, and they do seem friendly. They do seem like they want to be your friend, but they're not. They're out there to protect the public, to bring an action against you, and so do not be fooled. They are not your friend. Okay, and so never answer any questions from the medical board until you speak to your attorney and have your attorney present with you. So what happens is when there is an investigation and the investigator puts together their file, they'll summarize their interviews, they put together a report, they may have recordings, they'll have the records from the patient, perhaps billing records or police records and things like that. That'll all be given to an expert to review, and then the expert will then determine whether or not any laws have been broken, whether the standard of care has been met, and whether further action is warranted. Okay, and based on that recommendation, the medical board will take action or will close the case. What we've heard is that there is a medical board expert reviewer shortage, and so there are openings for expert reviewers. There's some information here on the screen as to how you can become an expert reviewer and how you can be compensated for your time as an expert reviewer. And ironically, or somewhat sort of cynically, if you are an expert reviewer, and you think about it, if you're given a file and you review that file and you recommend further action, well, guess who they're going to call for the trial? They're going to call you, and that's going to mean more time, more revenue for you to provide expert testimony and to appear in court. So there is a bit of a paradox in that as an expert reviewer, there is a implicit incentive to find cost or discipline and to encourage the bringing of actions, because you're going to have more work and more revenue as an expert.
Thank you, Jehan. That's a lot of information, and we're going to have a Q&A session. I wanted to wrap up with a couple of thoughts about what we just heard. One thing I want to remind you is that there were like 9,715, I think, actions in the statistics that Jehan went over, which was the 23-24 year. The 24-25 year annual report will come out in October, and so we always update everything with the latest. But that showed that the less than 4% of those 5,700 complaints, less than 4% had any administrative action. This is a testimony to the good work that you physicians are doing out there on the front line. And we want to acknowledge and thank you for that, because you show up every day, you're taking good care of patients. And the thing that is most frustrating is the little black cloud that comes with a medical board investigation. Historically, even a physician who is exonerated and doesn't go to investigation is looking at 12 to 18 months or longer. And because of COVID, it went even to 36 months during COVID, because first of all, they have a shortage of reviewers. And I really want to tell you the shortage is because the people that are mostly reviewing are the academics, and they're important and they're great, but they teach medicine. They're not community-based physicians, and their investigation and their review for the investigators comes out somewhat different than community-based, who are in the trench every day taking care of people. And that's why the shortage is for community reviewers. And we've been encouraging people to consider this. The training is provided and it's virtual with the medical board. And it's really higher than what this is from their website, but you can go to their website and see. But I'm just saying, if you looking for something else to do, and I have a number of physicians that are sort of in the twilight of their practice and they're doing this, and now they're retired and they're loving it to be a reviewer, because you're really there making the story and you're making the point for the community physician, not the physicians who are in the ivory tower. We have to do certain things to get CME credit to meet the requirements of the Business and Professions Code, and we did, because I have a slide on cultural linguistic competency and I have one on implicit bias. You have a very culturally diverse population in your service area, in everywhere in California does, and in your own groups you have cultural diversity in your staff, and that's a good thing. And so there's no issue, but we have to include that. These are some resources that have to do with some things that are sort of specific to our topic tonight. Jen will send out the slides, and you might have them already. And if you just click on the blue topic, it'll take you directly to the article. My last slide is an 1814 proverb. A man who is his own client has a fool, is his own lawyer, I'm sorry, has a fool for a client. And I want to say that I've lost count of the number of physicians who say, I didn't even know that my carrier would help me with a medical board issue. So I went to my neighbor, he's a tax attorney or a real estate attorney, or my cousin or somebody. And they said, it's attorney, the law is the law is the law. It didn't bode well. And also there was a slide that showed that the reimbursement for cost was like $27,000. That was on a very minuscule thing. And what most of the time now, if you go into probation, you're going to see six-figure numbers in the follow-up. So if you want to get CME credit, remember we now use the Cloud CME platform. We started it in March 2024. If you have a Cloud CME account with a university or another hospital or an organization, you will not find our code on the code, which is 4096. You have to set up a doctor's company account. It takes about 3 minutes to do all of this. And Jen has sent out and will send out again. And you just, once you set up your account first, it says create new account. And then you go in and you just claim the credit and they will send you an email to your email address. Do not go into the doctor's company and set up a doctor's company account where they ask for your name and your policy, then you're in the wrong place. So just click on education and you will get there. And with that being said, I would like to end my slides and I'm going to turn it back over to you, Jen, for the Q&A.
All right, Kathleen, if you want to stop sharing your screen, perfect. Just a couple questions real quick. Kathleen, if someone gets a phone call from a medical board investigator, how can they confirm it's a legitimate call so they know it's okay to speak to that particular caller?
Well, you don't know it's okay and you can't confirm, and that's why the goal is to learn to say, I'm sorry, I can't speak to you. You'll have to speak to my attorney. Please send your questions to my address and at my practice to my name. You do not. There are scammers out there as well. And can I tell you how many callers I get every month that a doctor talked to someone and it's a scam? So thou shalt not, as I made it a commandment, thou shalt not speak to anyone in person or on a phone without your attorney with you. And the attorneys, they do a lot of virtual meetings. They don't do so many in person anymore as they do them virtual. And that's it. I'm going to ask Jehan to weigh in on that response.
Yeah, no, I mean, I don't have too much more to add to that, Kathleen. Yeah, definitely don't talk to them. Definitely have them provide the contact information, and then have your counsel reach out to them. We know most of the investigators, and so it's going to be pretty hard to get one over on us at least. But yeah, we're going to know if they're legitimate or not. And frankly, you should be talking to them anyway. So yeah, don't talk to them.
Just say, on the advice of my legal counsel, I'm not able to speak with you. Send your questions on your letterhead to my office. That's it. Same if they approach you in person.
The next question, my patient threatened to report me to the medical board as they did not like the outcome of their plastic surgery. Is it okay to dismiss the patient for threatening me?
Yeah, I think it's fine to dismiss the patient and make the appropriate referral. Tell the patient, hey, you know what, you're probably gonna be better served by going to another physician. And here's some names of some physicians who I recommend in this particular area. Sure.
And then regarding the various complaint types, can you give some examples of the personal conduct versus the unprofessional conduct?
I'm sorry, for the personal conduct?
Yeah, what are some examples of personal conduct versus unprofessional conduct?
Yeah, I mean, a lot of these categories are sort of overlapping, if you will. So you're almost never going to see just one cause of action. You're going to see two or three, even though it's all from the same set of facts. So, for example, maybe one domestic violence incident, or one DUI, or one billing fraud scheme is going to lead to three or four types of claims against your license, right? And so, yeah, personal conduct and unprofessional conduct are going to be more or less overlapping. And I'd be hard pressed to give you an example where you only have one but not the other.
Kathleen, has the California legislature approved the medical board budget to fill the compliance liaison unit positions?
Yes, they have, and I understood it was funded in the budget that was passed in the fall of 2024, and but nobody can tell us who is in the liaison unit, and they won't answer questions about what kinds of positions or what are the positions that are they open, are they seeking employment. I think that they've had a slow start at the beginning of this year for a lot of reasons, that a lot of things going on. And I think that we don't know, but we're still trying to find out. And I'm hoping by the time we have our next meeting that we'll have some good insight into that. But I will tell you that I understand that they're hiring people, that they're not hiring physicians in that unit. I was told, and they aren't hiring attorneys. They're hiring people. Nobody knows who they're hiring. Jehan, have you got any insight?
I really don't. I can tell you that most of the folks we deal with are just sort of regular civil servants. They don't have a particular background in medicine or in healthcare before they take that position with any of the boards. As you mentioned, the Department of Consumer Affairs, who does the investigations, a lot of them are former law enforcement or have a law enforcement background. But as far as the rest of the staff goes, not most of them have no sort of healthcare background. They're mostly on the job training.
Let me check the Q&A. Couple more. Dr. Mallet says his brother is also a physician. Is a discussion with him discoverable? That's the first question.
Well, I can't give any specific legal advice in this Zoom, but generally speaking, a discussion between physicians unrelated to patient care would be discoverable if they're not, unless they're married, right? Because there's a spousal privilege, there's the attorney-client privilege, there's the patient privilege. But if one of those doesn't apply, then yeah, there's no brother or sister privilege.
A second question, how can the board justify high monitoring fees of $4,000 for an hour of monitoring fees? Physicians would not be able to justify this amount.
Yeah, it's kind of the same as the sort of $700 hammer or the $1,000 toilet that the government buys, right? There's just a lot of bureaucracy and red tape involved in what they charge. And so there really is not much you can do when it comes to those fees and costs. When it's the result of an actual trial or hearing, as we call it, right? Now, if you're talking settlement, if you're negotiating a settlement, then you can negotiate some of those costs down, right? They can say, hey, our cost of we want 5 years probation, and our cost of investigation are $10,000. And as your attorney, I can say, look, my client will accept 3 years and $5,000. So you can negotiate that in settlement and get that lowered in settlement. But if you go to a hearing or what you consider a trial and you lose, that number is fairly set in stone.
I wanted to share that I had a physician. Well, we've dealt with a lot of physicians that get probation, but the one I'm thinking of most recently, he was on probation for 3 years. And by the way, when you're on probation, you have to notify the health plan networks, and most of them will not let you bill. You're on a cash only practice when you're on probation.
Yeah,
you cannot.
You're going to be out of network. Sure.
Right, you're out of network. So what I wanted to say was he did not get to pick who was his probation monitor. They picked a physician from UCLA, and that physician's fee was $750 an hour, and he had to meet with them at a certain period for certain intervals for a certain amount of time. And they were able to do a lot of it virtually, but it was very expensive when you think about it, because he had to meet with them every quarter, at least 3 times a quarter for 3 years. And that was just for the monitor, not even. And I felt bad. This was a doctor who had to sell his beautiful home to pay what he had, which was about $380,000 in expenses once he was finally, over, when it was done. And he couldn't, and like Jehan said, you can't get your license reactivated until you've paid it in full. And he had to sell his home to do it.
Looks like we've got one last question. Jehan, does your office also handle allegations of wrongdoing by Medicaid, Medicare, and HIPAA?
Yes.
So we'll send out all the contact information for both Kathleen and Jehan tomorrow when we send out the slides again, as well as the instructions on how to claim CME credit. Let's see, I don't see any other questions in our chat box or the Q&A. So I do want to thank Kathleen as well as Jehan for a terrific presentation. Thank all of you, our attendees, who took time out of your evening to join us. We've mentioned it before, but if anybody would like to receive the slides, they will be sent out tomorrow. If anybody has any suggestions for future webinar topics, we're always happy to receive those. So please send an email to sdcms@sdcms.org. And lastly, if you are a physician and not yet a member of the Medical Society, I would encourage you to consider visiting our website, which is sdcms.org, where you can find more information on the benefits of membership, and you can easily join online in less than 5 minutes. Thank you, and have a great evening, everybody.